All right, hey folks, the Ninth U.S. Circuit Court of Appeals just upheld open carry as constitutional. This has huge repercussions, and I wanted to walk through what exactly it means and where we're going from here. And to help me, I have lawyer Stephen Stamboulieh, who is co-counsel to Alan Beck for the court case that was just tried in Hawaii. So, Stephen, say hello.
Hey, nice to see
Fantastic. Yeah, man. Hey, thanks so much for fighting for the Second Amendment out there. And hey, congratulations on the big win.
you. I appreciate it. I really do. Thank you.
Question: did you do it because you're interested in defending the Second Amendment, or did you just want a trip to Hawaii? Be
This
honest, honest,
this
honest.
this is all about the Second Amendment and bringing back what the Second Amendment means, and letting people have what they want to use to defend themselves with.
All right, so you were co-counsel to Alan Beck as the attorney that worked that case. Is that correct?
That's right. Alan Beck actually took this case pro bono when Mr. Young was dismissed from the district court and took it up to the Ninth Circuit, filed a notice of appeal in 2012, I believe.
Mhm.
And then I am, Mr. Johnny Come Lately, I came in around October of 2015 to assist in any further proceedings in the court.
You said 2012.
Yeah, so it's August 9th of 2018. I believe the notice of appeal was filed December of 2012. Yes.
So, Second Amendment supporters are excited about a decision that's actually been in the works. I mean, this case, George Young has been going on for 6 years.
A little longer than that. So this is his third case that he filed. We had the 2008 decision in Heller, and he had filed a case. It was dismissed. And then we had the McDonald case, which incorporated the Second Amendment as to the states. He filed a case that was dismissed. And then this is his third one that Mr. Young filed on his own. No attorneys out there to help him in Hawaii. And then it was dismissed. And then Alan Beck's like, hey, come on. And so he filed a notice of appeal. And, to answer your question, nothing's free. It's not a free trip to Hawaii, but it is that we are very, very, very pro Second Amendment.
So, all lawyers are supposed to be liars. You're a lawyer, ergo. No,
No,
just
they're
kidding.
spelled differently.
Gotcha.
Yeah,
Very
yeah,
good.
that's
That's
right.
awesome. Hey, so this is a case that's been going for a very long time.
Right.
And for me personally, I know everyone's real excited. I'm excited too, but I'm not really sure exactly what this means. Does this mean, hey, Ninth Circuit, it's all those Western states guys of California and Oregon and Washington and whatever. Can I strap two twin cannons to my thighs and go skinny jean shopping in downtown LA? What's
Well,
this mean?
you can do anything you want.
Yeah.
However, I simply wouldn't do that yet because, while this is a ruling from a three-panel court three-panel in the Ninth Circuit, the county of Hawaii has actually asked for an extension of 45 days or until September 14th to file a petition for rehearing in front of the same panel or a petition for rehearing en banc, which means in the Ninth Circuit's a little bit different. So they have an 11-panel en banc court, whereas normal circuit courts of appeals would go in front of the entire court. The Ninth Circuit's a little bit different, where you're going to have a smaller en banc panel than the full court sitting. Just kind of like they did with Peruta. If you recall, Peruta was the one where they said that you have a right to conceal carry outside your home. And then the court on its own went en banc with an 11 panel and then said, no, you don't have a concealed carry right outside your home, period. The interesting thing in that case is that they said, we're not even going to address whether or not you have a right to open carry. All we're talking about is concealed carry. And so that's why Mr. Young's case is so interesting, because Mr. Young said, I want everything. I want concealed carry. I want open carry. I want to be able to carry knives. I want to be able to carry a stun gun or a taser. I mean, he's basically attacking the entire Hawaii revised code for weapons.
And so taking it before what's reputed to be one of the most liberal courts in the country, how in the world did you pay someone off? Did you threaten someone?
No,
What,
no,
again,
no.
honest, be honest,
It's
turn over a new leaf.
we had the laws on our side. I mean, it's as easy as that. Hawaii has both concealed and open carry. in theory. In practice, they have neither. So they have provisions in the code that allow for either open or concealed carry, but they don't issue permits. And if you watch the oral argument, their attorney admitted that they haven't issued any permits. So you can't have a law and then that allows you to get either concealed or open carry and then never provide a permit under that law. I mean, what's the purpose of that?
Right. I personally have trained somebody who has a concealed carry permit for Washington, D.C. And,
There you go.
when he first told me that, I'm like, wow, that doesn't happen very often. I think like on the books of D.C., there's like 60 that have been issued.
There,
Ever.
actually,
like
I had this
ever.
conversation when I was in DC this past weekend. There's 1,600 right now that are active permits in Washington DC, and I
Okay,
actually
gotcha.
met the first person that got his. Leon, I think his name
No.
is Leon Parker.
Wow. Okay.
Yeah,
Well, I
yeah,
was way off, but regardless, I mean,
but still,
that's a unicorn finding someone who has a DC carry permit. So
it is.
I understand that there's the law, but then there's all these loopholes to really circumvent and take away that Second Amendment right, so that you get in big trouble for it. So there was a 3-judge panel, and 2 of the judges ruled in favor of. So now you should be able to open carry, but because they challenged, it's got to go kind of back to the gauntlet. So
Yeah,
it's
it's
the law is it should be there, but we're not quite there. So keep
we're
your
not
guns
quite
up, or
there.
what
Yeah, we're
needs
not
what
quite
needs
there.
to happen before I can go skinny jean shopping with my cannons.
So what's going to happen is they're going to file their petition for rehearing on or not. I mean, they said that they were going to on the 14th of September, but there's always a possibility that they decide not to fight it. The makeup of the Supreme Court is going to change when Kavanaugh gets appointed or gets
Okay.
confirmed, I should say, by the Senate. So it's going to depend on what Hawaii wants to do, because if we can game theory this for a little bit, let's say they don't file a petition and the Ninth Circuit now just says we have a right outside the home. Well, so be it. If they do decide to contest it and the Supreme Court takes it and then they say, no, not only do you have a right outside the home of open carry, you might also have a right outside the home for concealed carry. Well, that's going to irritate places like New York, basically all of the gun unfriendly states.
Right.
We can leave it at that.
Okay. Kind of where do we go from here? What's the worst case scenario? Like, oh, please don't let this happen. And then what's the best case scenario? And then what's the most likely course of action from right here? What's look into your crystal ball and use your brilliant head up there to tell us what's happening.
There's a couple different things that can happen. I mean, there's some things that I don't want to come out and say what my thoughts are on what I could see happening or how they might be able to beat it. It all really depends on what the county of Hawaii does and what the state of Hawaii does on September 14th. And we'll be able to know much more about, like right now, we're all just talking hypothetical because they haven't filed a petition for rehearing or rehearing en banc. So there's nothing beyond right now. There's a panel decision that's kind of effectively stayed because the mandate hasn't issued yet. So it's kind of this weird legal limbo of we're not really anywhere other than we have a decision, and we have this expectation that on September 14th they're going to file for either a petition for rehearing or rehearing en banc. Worst case scenario is status quo. I mean, that's always the worst case scenario for people that are trying to push gun rights, such as us. We want to make it to where normal people, just average people, can defend themselves outside of their home. Heller talked about the right is most acute in your home. Okay, well, that presupposes that we have a right outside the home. If something's more acute here, then we have to go, beyond just the core. We have to go beyond just where the right is most acute. We have to assume that there's something beyond where it's just most acute.
Right.
And so, it's left up to the court. I mean, if the en banc court gets it and says there's no right outside the home, then, hey, Supreme Court, here we come.
So if they rule kind of contradictory to the last opinion that was issued, you're like, yes, contradictory. We're going to the Supreme Court, and that's wonderful for you, right?
we're going to the Supreme Court if that happens.
Good.
No questions. I'm not saying they're going to take it because they got, the Supreme Court is a whole different animal. They have to, vote on whether or not to take a case. We need 4 justices to say, yes, we're going to grant certiorari and we're going to take your case. Well, I'm not going to go on the record as to who I think will grant it, but if Kavanaugh gets confirmed, we'll have a very good chance of getting certiorari on a good circuit split.
Gotcha. Very good. Awesome.
Because DC just came out, within the past 6-9 months with the Wren and Grace cases that basically turned DC into a shall issue, not a state, but territory, whatever you want to call DC over there. So there's a split. DC says, hey, you can carry outside your home. Hawaii says, no, you can. California with the Peruta said, you have no right to conceal carry outside your home.
Right.
Well, we'll see what happens.
Man, just personally, I feel indebted to you for, man, you're fighting a different fight that I don't know how to do, but I mean, we're all kind of watching with bated breath as this gun control and fight for the Second Amendment's going out, and you're right there in the front line. So, man, holy cow, congratulations, way to go, and big time thank you.
Well,
I want the right to open carry, though I will never exercise it unless I'm like, I don't know. I want the right, but I'm not going to use it. But anyway, I want that to extend like a toe in a door, so that we can push that door open wider and really get a full realization of the Second Amendment. And I know you're a believer. We've had conversations prior to this, and I appreciate your passion for the Second Amendment and for extending that to the common man. And so thanks for your work and effort.
What we have to think about is the client in this case, Mr. Young. He served his country for 21 years. He was good enough to carry a gun in Vietnam. He comes home and he's stripped of his Second Amendment rights. He's been doing this for over 10 years, almost as long. Half as long as he served in the military. It's just unconscionable to me. And props to my co-counsel, Alan Beck. He was told, this is a loser case.
Yeah.
You're not going to get anywhere with this. And, shockingly, you don't see any big organizations behind this, do you?
No.
Oh, okay. Okay.
None.
Oh. Yeah.
Hey, while I've got you on, how quick can you get the Hearing Protection Act passed for me? Because I've got, don't laugh at me, man. Come on. There's a whole bunch of people like, there was no joke here, but I've got some cans that I really don't want to wait on right now. And so it'd be convenient.
Man, that's like, I could talk for hours on suppressors and the NFA and what the FBI is doing now on the delays for, I don't know if you've heard about this. The FBI, with post 41P, right? You have to submit your fingerprints, your photographs, and all that other nonsense for the trust.
Right.
The ATF kicks over your application to the FBI. If the FBI denies your background, they won't let you appeal it. Their position now is they don't handle appeal for NFA items. Even though they run you through NICS, even though they generate an NTN, the NICS transaction number, the FBI's formal position is that they will not process that appeal. So I sued them a couple months ago.
You don't say no. Everything's appealable.
Right.
That's part of the whole America thing.
We have this thing called due process, and
right.
Sometimes our government forgets that, there's a lot of things they can do to us, but you have to go through the right process to do it. So the FBI, and you can look it up, it's Umbert versus Jeff Sessions. We sued the Attorney General on this too. I have 8 plaintiffs. A couple of them are force suppressors, an AOW and something else, where the FBI has said you're a prohibited person when they're not, and denied their Form 4, which already takes 8 to 10 months to process, a ridiculous amount of time. When you duck hunt at all or hunt anything like that?
Just people once upon a time.
So
that's a joke, but that's also not a joke. But I said it as a joke, but it's not a joke. Go ahead.
So you can go to Walmart, and on your hunting license, you can get a federal waterfowl stamp, $5, $20, whatever it is. I haven't bought one in 20 years.
Right.
But Walmart will physically affix that stamp to your license. Why can't my Class 3 dealer I pay my $200 to him, and boom, right there, point of sale, affix it to my Form 4, and let me go on my merry way.
I don't know. None of it makes sense. It's weird to me. I've watched ATF agents, alcohol, tobacco, and firearms, the regulation and interdiction of trafficking of firearms. That's kind of ATF's deal. So if an ATF agent goes into a gun shop to buy a gun and doesn't have a carry permit, they have to submit to a FBI background check on the ATF agent, and it's already got like security clearance, background checks, and they're the agency that regulates firearms. And then the background check from the FBI, I've seen it not go through, and the ATF agent couldn't get their gun, had to come back later once the FBI, and then they have to pay tax on something when they're paid in taxes anyway. But it's all just kind of backwards, and I don't understand any of it. It just looks like chaos to me.
Well, none of it makes any sense.
Yeah,
it's not made to make sense. It's made to trap people and to make it as difficult as possible. And unfortunately, that's the state of our law right now.
That's awesome. Hey, Stephen, you try all kinds of cases and represent folks. You were telling me about some case you had where you were helping some guys with machine guns and just all kinds of stuff. Real quickly, can you kind of tell us all the stuff that you're doing and stuff that's out there?
So Alan Beck and I filed machine gun cases in Texas and Pennsylvania where we said that the Second Amendment protects machine guns. As you can imagine, the court said, no, it doesn't. It only protects guns that are in common use. And even though the government may ban something before it reaches common use, that's totally fine, totally okay. And so we lost those cases. We filed a number of cases, one in New York that we're litigating right now, to give the people access to a stun gun or a taser. Like, New Yorkers can't even carry a stun gun. I mean, you can't even have one in your home. We filed the same against New Jersey. They folded within probably 4 or 5 months after we filed. And then we filed another one of those in Hawaii. I mean, it's something that I personally probably wouldn't carry. But someone like my wife, who just doesn't really want, she doesn't have the will to use a firearm, would have the will to use a taser or something like that.
And folks listening, stun guns are a stupid idea. And maybe if you're a cop, you can go with it. But anything, do a taser, not a stun gun. Stun gun you hold in your hand, taser shoots. Stun gun, you take a stun gun and you zap someone with it, and that's something you hold. They recover immediately when the electricity stops flowing, and they're mad as hornets. So your wife zapping some, back alley 200-pound thug, they're going to be very angry, and she won't get a second chance to zap. So anyway, and then taser's failure rate of, I'd almost prefer just some gnarly pepper spray to those two tools. But still, of right to bear arms and protect yourself, I want the right. I should have the right, as an unalienable right, as the right to life. Life means the protection thereof of that life. So anyway,
and you should get to choose what you want to carry.
Absolutely.
Maybe you're uncomfortable with the firearm. I've watched your videos and you're not, but maybe you are one day, and you only want to carry pepper spray. Right. Hey, brother, that's your choice. Or maybe you only want to carry a taser. That's your choice again. The Second Amendment doesn't say you can only carry a black powder pistol. I mean, in Hawaii, you can't even carry that.
Right.
And in New Jersey, you can't carry it.
And really, to me, stun guns shouldn't be in there. Tasers and stuff, and stun guns or pepper spray, that shouldn't be an issue anyway. That's not a Second Amendment issue. That's not arms.
It is. It's an arm. Anything that you have to go back and look at what is classified as an arm.
So pepper spray
can be considered an arm.
Well, then is bear spray?
Bear spray is regulated by the EPA. I can use it as a tool, as self-defense.
Great. So I'll just get pepper spray, and it has bear on the side. It does the exact same thing, but one's an arm and one's not. Functionally, they're literally exactly the wasp spray can have literally the exact same effect, but it just,
what about a machete?
Yeah, sure.
Absolutely. And even New Jersey said that.
Yeah. Cool.
So, there's lots of different things, except a paring knife was not protected by the Second Amendment because its utility is not for self-defense. It's for cutting fruit.
Fair enough. I just find it all very odd and very silly, and I'm just kind of like, back up off of me and let let good people protect themselves,
Absolutely.
right? That's it.
all we want.
That's
all
it.
we want.
It's not too much to ask.
We don't want guns to fall into the wrong hands.
Of course.
I FOIA'd the Air Force for the church shooter out in Texas, all his court-martial transcripts, and had the Air Force done its job and reported that to NICS, that dude wouldn't legally have been able to buy a gun. You know who I'm talking about?
Yes.
Yeah. And I've got all of that, and I make all of my FOIA, my Freedom of Information Act requests, documents that I get, publicly available online. The information should be free, so people can then read it and come to their own conclusion about what our government is doing and not doing.
Very good. Guys, we'll put that link down below so that you can find what he's talking about. Would that be okay?
Yeah, absolutely.
Yeah, all right, fantastic. So we can get to your information and how people can find you or talk to you or hire you or come over to your house and have a beer and
that's what I need.
accompany you to Hawaii and
all around me, just an FYI.
That's right. Guys, we're having a party. All of y'all, everyone, y'all are all invited. I'll put his address below in the description. So just show up, hang out, stay as long as you like. So it'll be good.
So I live in Mississippi, so we're a very gun-friendly state, stand your ground, castle doctrine, all that good stuff.
Why do you bring that up?
Yeah, just in case. There's a lot of crazy people in the world.
Yeah, I know. Absolutely. Yeah. Very good. Well, cool. Hey, thanks so much for coming on and educating me and everybody that's listening in. Keep kicking tail, and thanks so much for all that you're doing for us, man.
Absolutely. It's our pleasure, and Alan and I are going to go as far as it takes to get this case resolved.
Get it done, brother. Cool.
All right. Have a good one.
See ya.